Cloud.
It
Okay,
is
we're on.
recording.
We're on.
Okay. So we can call to order the State Board of Landscape Architects meeting 11/17/2020. Okay, did everybody have a chance to review the meeting minutes of February 18th? And there were a lot of them.
Yeah.
And that was
Yes.
fun.
Yes.
Hey, Bob, are you recording?
Yes, Phil, thank you.
Recording, yep.
Yep, we're on. I did hit, yep, recording.
Right.
Thank you.
Were there any comments on the meeting minutes of February 18th?
No comments.
No comments.
A motion to approve those minutes?
So moved. Anybody second?
Sorry.
Second, I'm sorry, Dominic?
Yeah, sure.
All those in favor?
Aye.
Aye. Okay, moving to number 2, comments and concerns of any person present today.
I'm sorry, I got a little confused. You said February 18th, was it August 18th?
Oh, I'm sorry, did I?
Yeah,
Minutes
Yep.
were August 18th.
Yep, that was my bad. Thanks, Ann.
yeah, I got a little confused, like, did I
Can we,
miss?
Mark
I had
just
the-
wants this year to end.
I had the wrong, I did have the wrong document open. I apologize.
It's all right, it's okay.
Do we have
Mark, it
to,
looks like Phil Doyle is on the call. Do we want to hear him now?
yeah, I just want to make sure that I had the right agenda item.
Can we correct that February 18th versus August 18th? Do we need to correct that?
Yeah, I guess we probably should. I'll make a motion to approve the August 18th
Right.
meeting minutes.
I'll second that.
All in favor?
Aye.
Aye.
Aye. I'm having it.
So we had, okay, so there was a new motion. Dominic, you second, who made the first motion for the, well, okay,
Mark did.
Yep, I made the motion. Dominic seconded it.
okay.
And that's for the August 18th. So that'll just take place of the previous approval.
Strike from the record that we approved February 18th, because that was approved previously.
Correct. Or we reinforce that we approve the February meeting minutes.
Extremely approved, yeah. Excellent minutes.
So comments and concerns of any person present today is where we are. And as Phil mentioned, I believe we do have a representative from LADA.
Do we have to unmute him?
I just asked to unmute.
Okay.
Phil, can you hear us?
Yes, I can.
Okay, you're on.
Oh, good. It, apparently you can't see me, or because I can see you, but there's nothing here that says I can turn on my video.
Well, I'm gonna see if I can promote. Hang on, let me see what I can do here. I can promote to panelists, but that's gonna,
Yeah, I think you can promote them to panelists and then we'll see him and then you can
Yep, okay,
take
there
him
we go.
off as panelist.
Okay, Phil, you should have more controls now. There you
Yeah,
go.
Hello, Phil. How you doing?
Good, how are you?
Hi, Phil.
This setup is usually the way I think we all see municipal meetings. When you're making a presentation, they put you up at panelists. You guys all saw the letter that I wrote. We've run into a couple of situations recently. The letter really speaks for itself in both Farmington and Windsor, where the landscape architectural stamp is not enough for the individuals on the town staff to for those plans to go through the process and be approved. And the Vince McDermott's letter from 2015 seems to make it pretty clear that the licensing that is issued by the state for landscape architects does cover matters like specifically erosion control. And in most municipalities, we don't run into this issue. And in, for example, Windsor, we've practiced there for years. Farmington, we've practiced for years. And most of the individuals on the town staff level really ignore their underlying legislation. They have apparently laws in place that says who can do what. My guess is that many of those laws go back some number of years, or statutes, however they have positioned them. And they rarely revisit those statutes. Now, other towns, that you've all seen it, have, I'll use, for example, Canton. They change their regulations and they acknowledge what landscape architecture are empowered to do. But in Windsor recently, we've had Adam Kessler, who's the assistant town engineer, and I've documented it in my letter, say, well, no, we can't. We have an underlying law. And the underlying law says a erosion control plan must be stamped by a civil engineer. Doesn't matter really what the state has determined. And in Farmington, Bruce Sear, who has moved from the engineering department to the planning department. He's now, I think, titled assistant planner to Shannon Rutherford, who's the acting planner. He's taken the position, the same thing. We got an underlying law. This is what the underlying law says, and we need a civil engineer stamp. And that seems to me to be a restriction in trade. It has troubled us. It is potentially costing my office money because we're continuing to do work in both towns, but now we've got to figure out how we're going to handle this situation. And we've talked to Oliver Gaffney over at Connecticut ASLA, and Oliver's been, who's president there, has been doing some training on this matter and other matters. And he has said to us that this matter should go to the Attorney General, but it should go to the Attorney General through you. That you act as the representative of landscape architects as a class, and that his research says that it should go through the Board of Landscape Architects, as opposed to me taking action as an individual to the State Attorney General. So on Oliver's advice, we've positioned this petition to you guys to say, okay, somebody needs to do something about this. We've got to establish, I think, that the state law is supreme, and that landscape architects can't be inhibited from the practice that is enabled by state legislation. So that's where we are, and I'm not sure what else to say.
All right, well, as board chair, thank you very much, Phil, for writing the letter. pushing this as far as you have pushed it. It's not something that we haven't seen before. Past boards have seen it before. Past board chairs have dealt with it. We've actually even had a member of this board who had a similar instance that happened in the previous year that we attempted to try and figure this out. So it's very unfortunate. I know the frustration. You bringing it up to us, we're happy that you're here. We're happy that we can discuss it. And that's what I'd like to do for a couple minutes with the rest of the board, is just sort of discuss it. I can give you my opinion is that in past instances, we've done a little bit of research. And I think that as far as filing a complaint, I'm wondering if we can do it two different ways. I think filing of a complaint, what we found out, and Bob Kuzmich, if you want to chime in here, the filing of an actual complaint does have to come from the individual being affected by whatever that decision may be. But if there's any way that the board can support a little bit more investigation by use of our assigned attorney to maybe be able to do a little bit of research on our behalf because we received a complaint, that's what I'd like to see. So I think it may have to go two different ways. But I offered up to either Phil or Dominic or Ann if they want to weigh in on this.
I'll take a shot, Mark. So yeah, I would confirm what you've just said. We have, of course, discussed this pretty extensively, and I believe we actually had one of the assistant attorney general staff come in and give us a presentation at one point. And he, again, to my memory, was very clear that someone has to be harmed. So a specific individual has to be harmed, and a complaint has to come from that individual.
Okay.
The
You
way,
know, if he defined harm, can it be financial harm?
I think it's a barrier to practice.
Yeah.
And frankly, the way he wrote this, and I was just looking at it, you know, and he can correct me if I'm wrong. I mean, he's bringing a complaint to us at this point. You know, it looks like that. The way it's looking for guidance and help in the form of he feels there's a barrier to practice. So, you know, he cited 2 municipalities, and you know, I think we can try to support. Like you said, we're kind of in a weird predicament where we don't have. You know, our DCP investigation division is like complaints against people practicing, but this is a complaint. I guess we should ask that question. Can our DCP investigation unit investigate complaints of barriers to practice? I don't know the answer to that. I know they're usually like if someone's practicing without a license, or if you know, so there's in betweens that they're looking at. And then I guess the second thing is you bring a complaint to the Department of Consumer Protection as well as Attorney General, because you know, frankly, he's being hindered in his practice in the state of Connecticut by a local ordinance, albeit there's a state law, and I don't understand the legalities, you know, of what Trumps want. I know most people fall to the form of whatever is the most stringent, and if that's what the town's doing, you know, and a lot of these ordinances, as he discussed, were probably put in place back in the 40s or 50s, never touched, or they've been updated. And we know that there's other ones out there that have been updated and they've been made more strict. But the fact still remains, in the state of Connecticut, he can actually, you know, stamp and seal erosion control plans. He can also create, you know, under our, go ahead.
And again, we were told in that presentation by the Attorney General's office that state law regulation does in fact trump local. Now, we've all heard local officials tell us to the contrary, and you know, being right and being able to act upon that are two very different things.
Correct.
Quite frankly.
Yeah.
Correct.
And I just want to make sure I give Ann a chance. Ann, would you like to make comment?
No, I'm just listening in, and I haven't, I've experienced it in a less direct way, where I was just told that I had to have drawings stamped by an engineer, and I didn't take it up with any higher authority or bring it to our board. But I agree that if this is state statute, then we need to make the state back us up and address this with the municipalities.
Yeah, I mean, the way we are a state licensing board. And, you know, we've always looked at it as, well, if there's somebody practicing without a license, that becomes an issue. You know, if other forms of complaints historically have been what have become part of a board discussion. This one seems like it's not going away. It may be a little different. You know, it's not a trip and fall from a design from somebody who wasn't a licensed landscape architect, which we have almost limited responsibility on those cases too. You know, although hasn't really been our purview, because we are a state licensure board, I think we should push a little bit on this one and ask again. I mean, we have went through this in the past year or two.
Yep.
And I'm not so sure we ever got what we wanted to get out of our first go around with our attorney general representative, or our attorney representative to this board. I think that because there's another case that we're hearing about right now, and case may not be the technically correct word, but another instance, this board needs to sort of protect that licensure side of it. And I think we should ask the question through our board executive of, here's a letter we got. What we advise this person to do is also file a individual complaint or through his practice complaint, but we'd like to be supportive of a board and push this issue a little bit further.
And I think where it ties into us is that barrier to practice under our license. I mean, there's an undue hardship that is written into that letter, you know, where he states he has some monetary numbers in there where, you know, he's either going to have to back off of that fee in his pricing, or he's going to have to sub that out, which we're speaking to the choir here, but he's going to have to, you know, bring someone in to do a review and stamp, and that's, you know, that costs money, and that's something that may not have been allocated based on the state.
Mark, would this be the time to get Bob's input?
Yeah, the only other thing that I would bring up is, you know, the state of Connecticut is charging for licensure, right? I mean, we are, whether it be application for licensure, ongoing renewal of licensure. Therefore, we need to support the license. That's how I see it. And if we're collecting money for a license that towns aren't accepting based upon law, that there's a problem. There's a problem there. So
Corporate license as well.
And corporate license as well. So Bob, I know it's a tough position, and you know, we're pushing a little bit on you to maybe do a little bit more coordination, but what's your take on this as a board executive?
You know what, I would, to get the ball rolling, Mark, as the chairman, if you could send me an email that I will forward to the board's attorney for starters as one path that, you know, concisely summarizing what the board's looking to do. Or for that, you know, you could send it directly to our representative. I'll find out who the rep is, who our legal rep is, but one way or the other, it's got to go to the board's attorney. And then I think a separate, you know, and then if Phil, if you want to file a complaint with our department also, and where it goes from there, you know, they'll advise you on that. I think that's a good idea also. But I definitely think as a board, Mark, you know, send me, or you could send the attorney an email directly.
Yeah, well,
for direction on where the board goes with this.
Yeah, I think it's the fact that this is, you know, it's been happened multiple times,
Yeah.
And we would just like to be, you know, have a resolution, be part of a resolution. I mean, if this all played out in a perfect world, I'd love to have letters written with some emphasis, maybe from the board or not from the board or from the attorney general to these individual towns, you know, just reinforcing it and ask for a response. I mean, that's really what we want to get is a response from the individual towns. So yeah, Bob, I would not send anything without CCing you on it, but if you and I want to coordinate on who that rep is, I have no problem doing it. I just want to make sure that Mr. Doyle make sure he's aware of the complaint process and how to actually file that, because that's something that will only help if we get that in the pipeline.
you know, what is the complaint process as you guys see it? Because I thought in sending this letter along that we were making a complaint. And Oliver had directed us to go, and it could, we're all new at this, but he had directed us to go to you guys as the board to be the appropriate messenger of this. So who should the complaint go to?
So Bob, I believe there's an online process.
Right. You know, Phil, what you might want to do is before you do anything, you can send an email to our, and if you would, our investigations director, Pamela Brown.
Okay.
She heads up the investigations unit, and simply state, you know, you wish to file a complaint. This is the issue. It's come before the board. Please advise me on, you know, the process and what I need to do first. That's, you know, the one path. And then Mark, as an aside, you and I'll get the contact to you of the board's attorney. And I think if you could represent the board in saying we have, you know, this has come before us and we're, you know, we need this to be addressed by the department, you know, and then if it needs to go to the attorney general, then they'll let you know that, you know.
And Phil,
It's your attorney.
I still believe this is the right process. We want to make sure we're not, you know, we may not be the be all end all on this end, but I think it's good that we're alerted, and then we can also educate you as a licensed professional in state of, you know, this is the process. You may have to jump through a couple other groups, and also that, you know, I think we're held up in the past is filing that complaint. A lot of companies, you know, you have to think about, you know, you're going to start filing that complaint against, you got to pick one, Windsor, Farmington, or it can be the generalization thereof. And that's where a lot of other individuals may have backed off a little bit, but it is coming ahead. I think they've been looking for someone to champion it, whether it's your company and yourself or someone else. But it's good that you brought it before our board so we understand and we can review that process as well. You know, in terms of looking at both, like we said, is it a barrier? And we can also kind of guide you in terms of, I believe it's a barrier. I think it's a barrier to practice against your corporate license. And I think Mark stating that, you know, you pay for this license, you fulfill a lot of state requirements, and then you're being hindered to perform your services within certain cities and towns in the state of Connecticut.
And I also agree with making sure that ASLA and the local chapter and Oliver stay involved in it too, so that there's pressure from every direction.
Yeah, Oliver is very supportive, and he has explained to us that similar to what it's almost like Dominic was reading his mind. What has happened in the past is that many times people get to a certain point and they say, I don't want to be the one to lead this attack. So, and over time, I think that's what we've all done. I know I've run into this situation before, and we found workarounds, but you know, workarounds stop after a while. And you know, using as an example, the project we're working on up in Windsor, these are big projects, and site disturbance on those projects are each in the 25 acre or so. So automatically they're going to the state for DEEP certification of the erosion control plans. And, you know, we've got the credentials to do that at the state as certified erosion control plan preparers. Yep. And if the state is allowing us to do that, not only through the regular license process that you fellows control, but at the end of certifying that, yes, we're qualified for preparing at the DEEP level, it seems to be an absolute insult to have Windsor turn around and say, no, we have a law that supersedes state law, and you can't prepare these. And because that affects not only me, but it affects my client and our fees on these things. This is the process we have to go through on the state level. is enormous, and because they require constant monitoring, and they have specific test sites, and we have the test kits. We've got to go out and monitor on a constant basis, and to not be able to do that, to have to turn that work over to people who are civil engineers who are as qualified, in some cases less qualified than we are, is really annoying. We have gone through extensive training, and we're complete as landscape architects. We're completely capable of doing this work, and that is has reached a point with Windsor was the thing that triggered it. That has made us say, okay, time's time. We've got to take a stand here, and I see this, and I'm sure you guys see it as well. You know, we've got another project, a 200-acre project down in East Lyme. And I was flipping through the East Lyme regulations, both zoning regulations and subdivision regulations yesterday as we were sitting down talking with the client. And in the subdivision regulations, you know that one has to prepare a conceptual grading plan. Sure, you've all done subdivisions with surveyors and engineers before, and that regulation says landscape architects basically aren't allowed to do that. Only a civil engineer can prepare the conceptual grading plan, and on the erosion control plan, they too do not allow landscape architects to prepare erosion control plans. So it's a series of towns, and I think we're at the point where we've determined that we've got to move this along. We've got too many other projects coming along in Windsor, and we've practiced there 40 years since Mario Zavarella was the planner. Where are you?
We can still hear you.
So,
yep, and so it's time for us to move this along. If somebody can give me the email of Pamela Brown, I'll email her. I'll also continue to let Oliver know what's going on. He has been sending us packages of information on what we should be doing, who we should be contacting, the powers of different organizations. So we're staying in touch with him for guidance. But I'll definitely go to Pamela.
Okay, so just to summarize,
Yep.
just to summarize, Bob, you're gonna get that information directly to Phil.
I'll get the email to you, Phil, for our investigation director.
And then Bob, I want to coordinate with you a little bit and make sure we get this in motion from the board's point of view, that we are seeking some resolution on it. And the more I listen to Phil talk, I see this as it may be coming up more and more now, because there's transition in all these departments, whether it be the town, whether it be the DOT, that people who have been influencers over the past 30 years are now retiring. And there's other people who are falling into these positions, assistant town engineer, new town planners. We all see it. And those people in new to these positions are maybe relying on the fact of what's in printed regulation, and not maybe educated enough to understand, okay, I'm focused on my city or town ordinance, and just really not be educated about what the law is from the state. And I think if the board's role could be one of almost an educational, well, here are they, so that we know that when these come up, we just can, sort of like the 2015 Vince McDermott letter. If something like that could be updated, just to be a little bit more clear, have a little bit more support, saying, oh, well, here, you're new. If we get a new town engineer, if we get a new town planner, assistant town engineer, assistant town planner, this letter, we can be proactive. And this can go out and say, by the way, this is what governs what a landscape architect can do and can't do.
Yep. And I think
be a little proactive.
Along the coast, what they're doing is they're updating all their drainage manuals, and a lot of those A lot of those drainage manuals, better and different, are being written by engineering firms. And once it gets approved by the council or the common council or the board of selectmen, that's gospel at that point. And it says,
Yeah.
a lot of them stipulate that we've seen coming through that, so, sediment erosion control, grading, all has to be done by a licensed. And that's kind of, maybe Mark's on the right point. If we're going to be seeing this in more cities and towns, we just have to re-educate them to say, hey, listen, if you're thinking about, changing your ordinance, your ordinance is old and it still states this, that you have to have some inclusionary language when you rewrite them.
Yeah, I'll be the curmudgeon here a little bit. I know I've been practicing almost 40 years and I've seen this throughout my career and Phil got to it a little bit. I think for one reason or another, it's just coming to a head. People are tired of seeing it. And Mark, you and Dom don't see it as much probably because you work for engineering firms and your plans are stamped by engineers. But yeah, as Phil said, we've always just gone around it, not wanting to make waves. And, I hear that from not sole practitioners, but single service practitioners across the state. If you're just in LA, you're seeing that problem. So I'm not sure it changes our approach. Well, I think it does change the approach a little bit. I don't know that quote education is going to do it. And I don't, and not to be negative, I don't know that it is solvable, but if anything's going to happen, we need to be pretty aggressive, I think. And how that happens, I don't know. I would like to see us as a board do something beyond just feel good tactics, if you will. Whether or not it'll go anywhere, I don't know. Even as you, Phil, I'm the one that brought a complaint. Been a couple years ago now. It went nowhere. Legislators, they all have other things to do. Again, not to be negative, we have to do something, but I'm a realist, so I just want to make you aware, what's going to happen. Things don't change because it's the right thing to do. I guess that's my message here.
Yeah, and I think to your point, Phil, this isn't going to be solved by a single letter. This has to be a multi-pronged approach. There has to be pressure applied from many different directions. And if we can be a part of it, other than just a update of a 2015 letter, hey, why not? If we can, as a board, we just have to make sure that we function within our duties and responsibilities. And I'm all for and support however we can to help, we should.
And I'll suggest something also. Bob, could we get a representative back in again from the Attorney General's office to go through the process? And if we can, and I hope we can, let's invite ASLA to come to that, because it's a huge bit of confusion in the profession. So again, if we're going to address this, let's address it hard and make our efforts worthwhile. And maybe we can kick the can down the road a little bit. So Bob, is that possible?
Yeah, I can contact our legal department and find out, who would represent the board at the AG's office.
Who is our representative now? Do you know?
Phil, honestly, I don't.
Because our longtime rep retired, correct?
Yeah.
Right. I'm not sure who took over for Peter. As you know, I was absent for a while from work. So
that's right.
So Bob, I'm wondering
that year.
Bob, can maybe we can do this jointly. This letter can also be a request to have support at our next meeting, because we want to have the ability to have that person answer some questions. So addressing this complaint and this letter from Mr. Doyle, also requesting that we get some support from the AG's office at our next meeting.
Yes. Yep.
And again, somebody specifically to go through the process of filing a complaint. Does state versus state law trump local law, those sorts of things. And Peter gave us a fantastic presentation a few years ago.
Yep.
We have new board members and different people. So I think that would be really helpful. And again, even more helpful if we can invite some landscape architects and leadership around the state to come in and start to understand that it's not a Well, I don't think, well, to make sure people understand, it's not a quick fix. It's not writing one letter, et cetera. It's a long-term sustained effort.
Yes, absolutely.
I guess a question I have is in processing a complaint. If I get in touch with Pamela Brown,
Yes.
and I guess she is with the Department of Consumer Protection.
Yes, she's our investigations division director with the Department of Consumer Protection.
Do I also send a letter of complaint directly to either a Department of Consumer Protection Attorney General or directly to the State Attorney General's office? Is it two complaints or is it one?
I think for now, Phil, you would start with one complaint to Pamela.
Okay.
And you can even ask in your email to her, the Attorney General's office, they represent the board. That's the board's representation in any legal matters outside the department.
Yep.
But as far as, as far as your communique goes, I would start with Pamela first.
Okay.
And see where she tells you to go with it.
Yep.
And
No.
Phil will be the one to get it to the Attorney General because they'll be representing us. So somebody at the AG's office will be aware of the complaint.
And that'd be good if they come to the next meeting because, we got to make them aware. We're seeing this more and more. It's a barrier. They've told us before they need a complaint from an individual. We as a board cannot file that complaint. The ASLA cannot file that complaint. So we just need to, put them on notice. Hey, this is third or fourth time in the last 5 years that this is coming before us. And there's obviously an issue here that we need to have them look at. So.
Yep. Over time, we have found that Vince's, hey, Terry, you want to come in? Yeah, my partner just came in the door from a meeting. But we have found that Vince's letter that was written in 2015 to be actually very effective. That letter, I'm sure you guys have seen it as well. Sometimes when this has come up in the past, we've shown people Vince's letter, and people have understood. They said, "Yep, we understand, and our law is old, and we're not going to enforce that local law." So that letter really has been an excellent letter. It would seem from what our recent experience is, that letter might need to ultimately be upgraded, perhaps with the assistance of the Attorney General's office, that would put the Attorney General's imprimatur behind that, saying, that maybe it's a joint letter that comes out from the board or is countersigned by the Attorney General that says local law does not trump state law, and that those determined to be able to practice at the state level are able to practice at the local level, not local laws notwithstanding. And we all know when you start looking at a zoning regulation or a subdivision regulation, there is a disclaimer at the very beginning of the regulation that says, well, if there's conflicts in the law, that doesn't entirely discount the law. And so no one is trying to say, gee, all local laws are incorrect, improper, but there are probably sections like this of local laws that are incorrect, and that needs to be clarified. So in the end, I think that's probably the solution that needs to be implemented, is something that comes from both the board, but is countersigned in effect by the Attorney General explaining that. Because I don't think any of us want to be in a position where we want to attack one particular individual, but we've got to get the message across that this is not an acceptable, it's not an appropriate resolution. Hi, Terry. Terry, my partner.
Hi, guys. Terry Hahn.
Hi, Terry. Hi, Ms. Han.
Hi, how you doing?
From the board point of view, and I know that there's a motion involved in this one, I do just want to, I don't see it as an attack on the profession. Deregulation and stuff like that, I do consider an attack. I think this is just a misinformation, lack of information. And I just think we need to bring this to a head, and however we can support and efforts to do this, we're going to be supportive of it.
Yeah, I agree with you. I completely agree with you.
Okay. Does anybody else on the board have a reaction, comment from what the direction that we plan on taking right now?
No.
So I think we're good at this moment. Don't believe we have to make any motions or approve anything. I think we're clear on what our direction is going to be moving forward. Mr. Doyle, thank you very much for bringing this to our attention.
And I guess you guys will send me that information on Pamela Braun's contact.
Yes.
I'll follow up with that. And then if you could just keep us apprised of what might be happening, maybe at the next meeting, if you are fortunate to get someone from the Attorney General's office in, it'd be interesting to listen to that.
Yeah, I mean, yeah, for once, it might be nice to have several people on public comment speaking in support of a direction.
Yep.
So I think that'll be important, that we don't wait till the last week if we can try and get a commitment so that we can, get the word out that if people do want to participate, if there's one silver lining, online meetings are easy to participate in. You don't have to drive to Hartford to present. So.
Yep, that's good. Okay, listen, thank you very much.
Thank you.
Thank you.
Yeah.
Now,
Okay.
Okay, everybody take a deep breath.
Need a drink.
All right. Number 3, DCP investigation. Bob?
I did get an email from our investigator that there's nothing to bring before the board in terms of complaints. They haven't received any complaints. They're obviously not acting on any right now, so there's no report at this point, fortunately. So.
Okay, moving on. Old business, number 4, item 1, which has been on here for a while. Discussions with UConn regarding outreach and understanding. I know that COVID has been tough on this one. Dominic, do you want to add anything?
They locked the campus down. So, you hear that?
Yeah.
It's sad to say. I mean, nothing to report at this point. It's not a good time to be either a regular school student or a college student. I don't envy either one. I mean, everyone has it tough, but it just, to distance learn is interesting.
Yeah. I know I'm the biggest one at fault on this one because I've been talking about it for years, but maybe there's an advantage of if this board can get some FaceTime via this format.
Yep.
with students, maybe that's even easier to accomplish. I don't know. I'm just, if Dom or Phil has Phil, I don't even know if you're still an adjunct there or teaching or.
Not this semester, but I am I think they call it adjunct instructor, but yes. So what's the question?
Well, I mean, we've always talked about getting some FaceTime with students or potential candidates, hypothetically going through the, after graduation, looking forward to licensure. Yep. If they could get some FaceTime with the board and ask questions.
No, absolutely. That's doable. It just takes a phone call or an email.
Yeah. So I don't know. I sort of pushing it off. If Dom had sort of taken the voluntary
I'm
role
willing to help.
of
If there's help out there, I'm willing to help out. But if we can, I don't think you had a licensure presentation. Is that still?
I do. We can still use that. There's no doubt about it. Probably
we can condense it down and then, this is the board. these are the regulations that you'll see, but you should be checking, I mean, there's probably a CLARB element to it because, give them a general understanding of, then we could give them some fast facts too. We roughly see
Yep.
X amount of people come through for licensure, and you got to take the exam at some point. And like you said, open it up for Q&A with them.
All right. What are we thinking about if we give Dom a challenge to set this up? I mean, they're going to be off. What is the school schedule? They're not going back after Thanksgiving.
No, I don't believe they are.
It's generally, Mark, Thanksgiving to mid-January for most colleges.
So I think that if we shot for, right after they get back, potentially, a February or January, February timeframe, Dom, if you want to put the feelers out there to see if maybe there's a right time, class period, something, we could then target, and between us, we could streamline this presentation. But I think it would be nice if, all of us were to make ourselves available, run through a quick presentation and be available for questions for, 30 minutes to 40 minutes. So I think we would target January, February, next semester.
Yeah.
Okay.
Good.
Okay. Item 2, continue and keep that on the agenda, Bob.
Yeah.
Will do. Yeah.
Okay. Number 2, continuation discussion concerning inconsistencies between the statutes, regulations, etc. I believe Bob attached something to our materials. He did a little bit of research. Bob, do you want to run through any of the stuff regarding the highlighted text?
Let me just.
Sorry, we're
bring it up
dumping
in
some
my,
things on you. Ann, are you still there?
I'm here. I've got the document in front of me.
Just checking.
Still awake. Yeah.
Yeah, I believe
Basically, there's one of the sections talks about a non-accredited program being accepted with 4 years experience.
Yeah.
And the conflict
Right,
is that previous to that, it says 2 years 2 years experience with an accredited program.
Yep.
I'm just going to go to the document here. There was a discrepancy with the statute and the regulation in terms of
Which, Bob? The first is the statute?
Right, the first, chapter 396, 2370 is the statute. Let me get to the highlighted document.
Hold on. There's no 2370 here.
I think he means 2370.
20-370.
Okay, under chapter 396. Gotcha.
Yep, I'm just opening it up here.
That's a good idea.
Yeah, there's a difference between the regulation, which I highlighted, and what it says in the statute. That was the main thing that I found. That the statute actually doesn't reflect, I believe, let's see.
Let's walk through your document for a second.
Right.
So if we start from the very top, we got regulation of the Connecticut State Agency, State Board of Landscape Architects 20-368-7A, examiner and licensure standards.
Right.
Okay, the 1 and 2 that you've highlighted, professional green landscape architect, College University, accredited by CLARB. At least 2 years of diversified experience in landscape architecture under direct supervision, and you complete the letter. Those are our 3 criteria under the examination for licensure standards. So then you go down
Correct.
to 396.
Right, that's in the regulations. Now, if you go to 396, I had it backwards down. In 396, it mentions the alternate path.
Correct.
Minimum of 4. So the discrepancy is the regulations are not consistent with what the statute mandates.
So the 20-368 is a regulation.
Yes, I'm sorry. Right at the very top of the document. Regulations of Connecticut State Agencies, 2368-7A. Examinations and licensure standards, that's in the regulation. Below that, chapter 396 with the asterisk, landscape architects,
Yeah.
that's the statute. And then finally, after that is what appears on our application. It's headed by application for landscape architect license. So the application, reflects the statute, the regulations do not.
Okay.
Okay.
That's what I could see. Follow? I'm sorry, I had it backwards.
And I want to take this a step further, Mark, is which one is Clark quoting? Which chapter are they quoting on when they're reviewing, when it comes into them? Are they quoting the regulation or are they quoting the statute?
This is not documented, but I'm
Well, and
pretty
that's-
confident
yeah.
they're talking statute because the application, they put more emphasis in the application. So I'm pretty sure they're quoting statute.
So on our application, we have it, 2 years successfully.
Or wait, I'm sorry, whichever the application matches. If the application matches,
The bottom thing, application for licensure. Is
right, which one does that match though? The actual statute? Yeah,
The statute, correct. Yep.
those are the two that go together. That would be what CLARB would be.
And here's where I have a rub, and I'm just going to inject. The in lieu of graduation credit college or school landscape architecture and such practice experience at that point may be admitted to the examination upon presenting evidence of, with consent of the Commission of Consumer Protection. And we've had people come through here, and I can tell you right now, I've been around long enough now that they're using the alternate path, but we've never seen it. Maybe the commissioner on his desk, he gets a review of this. That's where I have one of my issues. We don't see it. It goes to CLARB. They say, oh, you're all set, your alternate path. They're making that decision, and they have no right to make that decision. It has to come back to us at that point.
And we have beat this around before.
Yep.
And what the information that we got I think Bob came back, we researched it, is this board is in the right to review applicants prior
Absolutely.
to sitting for the exam.
I think
Absolutely.
I
That's
have
the
a problem
mandate.
with and I'm just going to be the curmudgeon, as Phil said. We've got a private entity in CLARB. Basically, they can review it. These people take the exam, and then we call into question whether or not they're actually qualified to sit for the exam because we didn't review it. And it puts us in a situation where, our hand can be forced. Well, they took the exam.
Oh, you're right.
He's got a Columbia degree in agronomy. He should be able to take pass the test. I mean, that's
Not going to let that one go, are you, Dom?
No, I'm not. Columbia, in my opinion, on record is trash. But that's just between you and I. That's where I have an issue. Is we're casting that final vote, but
yeah.
So I appreciate, Bob, I appreciate this document because it lays it out very specifically what it is. And I definitely.
Thank you.
Yeah.
You're
This is
welcome.
huge.
Thanks. No problem.
Because
It helps me out too. It's all in one place,
Yeah. Well, that's the thing. Like I thought I had the right one, and then you're looking at something else, and it was changed, and it's.
Hey,
So-
how about a real simple suggestion here? Is it possible to put a note on the application that, hey, if you have an alternate path, take it to the board first before?
Yeah, it's strongly recommended we review it prior. There's a lot. Let's be honest. We've had people come, they don't know, and they come to us, and we say, oh yeah, you're fine. And then they're on record that they came to us, and there's no question. It's the ones where, oh, I think I got a way to sneak in here something differently. I mean, it shouldn't be that way, but it is.
No, what Dom said is we're getting our hands forced when somebody comes to us with I passed the exam. Doesn't really matter what my schooling was. That feels a little bit, it's not right is basically what I'm trying to say. However, to the simple part of it that Phil just mentioned, I think there's a couple things going on here. We have the regulation and a statute. I mean, it seems like they should match better than they actually match right now. But that is going to take an act of changing things, which we know how long that takes. that's something that we shouldn't ignore, that we should probably say, all right, well, we need to amend these. Look how long it took to amend the last set. We're talking years. But is there a way to amend the actual application to the point we just talked about that says something like, you know, if there's an alternate path, by the way, you know, asterisk star star, see the board before you submit for your application to CLARB to take the exam.
So I've got a question. How does a person know that they're taking an alternate path?
If it's not landscape architecture, as far as I'm concerned.
But where are they aware of that? Is there some means to inform people that they're on a quote unquote alternate path?
Well, in the application right now, if you read it, number one, hold a professional degree in landscape architecture from a college or university accredited by the Landscape Architecture Accreditation Board. Number two, have at least 2 years experience. Number three, complete the CLARB. In lieu of graduation from accredited college or landscape architecture or school of landscape architecture and such practical experience, an applicant may admit a bachelor's degree. It's basically that number one underneath is having graduated with at least a bachelor's degree in a discipline related to landscape architecture or landscape architecture from a college that has not been accredited. Send it to us. It takes 5 minutes to send it to us. We review it. Yeah, you're fine. Okay, UMass isn't accredited, for instance, or I'm just throwing it out there.
I think that's what we do right there in that
Yeah.
clause. We
Yeah.
say, if this is your situation, contact the board before proceeding further.
Yep.
Now, my question to Bob is, Bob, does that take an act of Congress to change the application?
No, I don't think so. I think I just have to make sure it's clear with our legal department, but I'm just looking at this. I'm looking at the application the way it is right now. Where does CLARB factor into this? If a person has an alternate education, they have to come, it has to be approved by the board before, even if it's in the CLARB record, it would show that they have not met CLARB education standards, at which point the board would look at it and say, well, you know, what's going on here?
Here's the issue. Here's the biggest issue. And Dom has brought this up for a long time now, in that's true. We do get it, but we usually get it after they've passed the exam. Am I wrong with that?
Okay.
No, that's kind of what that's my big thing.
Yeah.
It says everybody come on in. Come on. Oh, you're unaccredited, doesn't matter. Come on in. You're forming your council record. You're an engineer. Okay, come on in. You're going to form your record. And then they say, oh, you can sit for the exam, and they pass it, which is fine. I don't have a problem with that. But the thing is, our statute is built on a three-legged stool of education, examination, and practical experience, none of which is discounted to the other two. You know what I'm talking about in terms of all three matter in my eyes. The education matters, the examination matters, and then your practical experience matters.
But would CLARB take it upon themselves to admit somebody that doesn't have an accredited degree? I mean, are they gonna, I don't, has that happened?
Yeah. Yes.
Yes.
It happened with Columbia.
Yep.
And that was master's program. So they had a 4-year bachelor's in something. I can't remember what it was.
Yeah, like
and a
flower
master's
arranging or something.
I'll remind everybody it's being recorded. They had a bachelor's degree and then a master's degree from Columbia School of Landscape Design, something like that. That's what it's called.
Yep.
And they came to us with a full CLARB record and a passed exam.
I'm reading the statute as you're talking. I'm just saying, you know, it's as determined by the board.
Correct.
Provided the curriculum is consistent with that of an accredited landscape architecture program as determined by the board, period.
Yeah, there's really no gray area.
And we're not denying that. We're not denying
CLARB is
that.
going in a different direction, then we have to notify CLARB and say, you know, you can't do this. Anybody that's going this route, they have to flag us and say, you know what? You need to contact the state board. I mean, that I would think, Dom, right?
And that's fine too. I just think they have to just be notified then. That's
yeah. Yeah, I guess Okay, maybe it was during the time I was out. I don't remember that. And that.
And like you said, Mark, I think it might be twofold. Maybe it's talking, and I think I know someone who could do that.
Yep.
Also, it's I still think it should be on here that says, before you take the exam, it's stated in here, but I don't think it's called out. It's not in bold that, please, in lieu of graduation, if you're going to go the alternative route, contact the board.
Yep.
And we've had people do that. Lauren Holy
absolutely.
had a certificate from California, and she came to us and she walked us through her education. She walked us through everything. And I'll go on record. I researched the Columbia degree, and I compared it to other master's degrees in the state of New York, both environmental science and forestry, Syracuse, and at Cornell. And it's not even close. It's not. It's half the amount of credits each semester. I get it's a master's program, but if you looked at all the syllabuses of the courses, it's not. It doesn't compare apples to apples in terms of. And you got to remember, in New York, their license is under education. When they look at how they're doing that degrees, and as a personal citizen, I talk to both the department head at Syracuse and at Cornell, because they have a right to know that someone's offering something that really doesn't make much sense.
And what was their response, Don?
I know Cornell's looking into it. They're looking into it, and ESF is quasi looking into it. But Cornell, he was very happy that someone had called him and brought it to his attention. If you're looking at it, advancing a degree program, that's fine.
Okay. So just for the sake of time, two items coming out of this discussion would be, one, we have to contact CLARB, and I have brought this up, but I haven't pushed real hard on it, to find out specifically how they handle somebody that could be following an alternate path, which to them should be, we want them to flag whomever does not graduate from an accredited university and send it back to us. Could it be that simple?
And some of them are no-brainers. Yeah, I think that is, and that's, some of them are no-brainers. Someone loses accreditation and they're working towards it again, or, there's ins and outs. UConn had in the 90s where they weren't, and you look at it and say, okay, that's acceptable.
We'd just like to see it first.
Yeah.
And then the
And
item
again,
number
Mark, in other words,
item two coming
issue-
out of,
in other words, you're going to put this. I'm sorry.
go ahead. Bob.
Okay. So the gatekeeper really, we have to notify CLARB. I mean, right now it says in the statute. I'm just going to I can't bring this up. It says in the statute that it's on the application that the curriculum for this alternate path has to be determined to be approved by the board. But I think you said we have to notify CLARB that people approaching them are applying for a CLARB record that have this alternate, non-accredited 4-year degree they can't. I don't know how we do this. I mean, we're saying they have to come to us before they get permission to sit for the test.
Correct. It's not a CLARB record. Anybody can apply for a CLARB record if they want to. It's requesting to sit for the exam. If there's an alternate, if they don't satisfy the normal criteria and they're going for an alternative path, we are, number one, I want to understand how CLARB is handling it. And right now, without knowing the details, I think they're just pushing them through. We would like to be notified and have CLARB say, contact your state board prior to get information prior to us saying you can sit for the exam.
Right.
But item two is, can we change the language immediately just to reference, hey, by the way, here's the statute. If you're going an alternative path, contact CLARB or contact the state board prior to submitting application for exam to CLARB.
I could try to put something like that in the application.
Am I correct on that, rest of the board?
Yeah.
Yes. Yep.
Yes. I have a question though about the, like if somebody's starting their CLARB record in another state and then they move and they come to Connecticut and they've already gone down this path.
Are they
I just-
licensed or not?
They're not licensed yet,
Okay.
but they've started their CLARB record in, I don't know, Michigan or something. And Michigan isn't as stringent. Maybe Michigan has adopted this statute fully. And I mean, we have too, right? In a way, it's in our
Did this-
statute.
Did this
Yeah.
person pass the exam or not?
No, not necessarily. But if
Then
they have, so maybe they have, maybe they haven't. I guess we have ultimate decision whether to license the person. And they could have been spending 6 years trying to do this thing, but they get to Connecticut and they find they can't be licensed because their program was not accredited or consistent with accredited programs.
And that could be the
And-
case. We're just asking the ability to review their education prior to them coming back with past examination grades.
Yeah, that's a
So-
different, for instance, and that can be handled by the board, multiple different ways. I mean, ultimately, we're the gatekeeper on that in terms of, allowing people, like, every situation. I was around when this thing got rewritten and I was part of it. And it basically leaves a lot of responsibility on determination by the board and the Commissioner of Consumer Protection on pushing people through to get licensed. And it's funny that you mentioned that, Ann, because right now that's happening to us. And we're going to see another one today from Massachusetts, which has no bearing on Connecticut, but they have their own issues. And we'll get to that later on in this meeting, where people are actually not even residing in the state of Connecticut, but they're getting licensed through us because they can't get licensed in their own states, or there's a barrier or there's a delay in getting.
Interesting. Okay.
So let's just
Okay.
stay focused on this topic. Bob, do you know what you have to do as far as language on this application? Or is that something that, do you want to hammer that out right now so that it's formal language that you can then
Well,
sort
right
of
now
push
on the
up through legal?
Well, right now on the application, it says in lieu of graduation from an accredited college or school of landscape architecture and such practical experience, an applicant may be admitted to the examination upon presenting evidence of the following. And then it says within that next paragraph, as determined by the board. So do we need to make that clearer? I mean,
Obviously, I think,
Yeah.
I think we do. I think it needs to be,
So we need to hammer out, maybe we can hammer out that language aside from the meeting, what.
Are you talking about the application or the?
application.
The application, language that going,
And now
that can be changed quicker,
And now that I'm looking at it, and we're not opening the statute and we're not opening regulations, but I can see the way the statute's written, we say the Landscape Architecture Accreditation Board. And then in the next sentence, it was never meant to be this way, but it says, as determined by the board. Someone could think that it's CLARB is the board in that, and the consent of the consumer protection. I can see where CLARB might be used on our statute, because that wasn't. It should say licensure board, not just board, but I know they struck it at the last minute when we rewrote it. I think legal they just wanted it just call it the board, not the licensure board for some weird reason. But I can see where CLARB is thinking, oh, well, we're the Landscape Architecture Accreditation Board. And then in the next sentence, it's determined by the board. We're determining whether or not. So understood. I know, back up to what Bob said. I think, if you augment it slightly in the application, I think we should be okay.
So I guess the question is, can we give Bob direction, or do we just want Bob to try and do it? And if we're all here, I wouldn't mind us throwing some language at Bob right now. I know we're running late, but I wouldn't mind just giving him a little bit more so it avoids back and forth.
Or you know what, is it possible to and not to delay it, but can you send me an email with what we settle on today? I mean, it kind of states it, maybe not that bold in the application as it stands, but it's not clear. It's got to be.
So I don't know. I look at this and I'm just looking at the sentence under the application in the Word documents where it starts in lieu of graduation from an accredited college or School of Landscape Architecture and such practical experience, an applicant may be admitted to the examination upon presenting of evidence to the board. Put it right there in that first sentence.
Yeah. Examination upon presenting evidence to the State Board of Landscape Architects of the following, right?
Does that
Because below
say-
it, in paragraph 1, it does say the curriculum is consistent with that of an accredited landscape architecture
Yep.
program as determined by the board.
I'd
Yeah.
put it right in
Consent of the
bold up
commissioner.
front.
What's that?
Put it right in bold up front.
Yeah.
That's
Yeah,
as
right
simple
it-
as I would go.
Yep. As determined by the
proud.
board, all cap.
Would you say to the state board?
Oh, yeah, I mean, I would find, yeah, I would
Yeah.
go back to how, I would try to be consistent with how the board is referenced. If it's whatever it says in the statute, I try to make it, if it says State Board of Landscape Architects, that's what I try to put on the application. So it's, just so that it's consistent with what the law is right now.
Yep.
But yeah, I would definitely, and I would make, but maybe you're right, Mark. We could put it right there.
Yeah, just be careful because the statute doesn't actually call out. It says board, it says consumer protection, but it doesn't say the State Board of Landscape Architect. It doesn't say that anywhere in that in the actual statute.
There is a reason why, and I now remember why, but.
That's why, Don, you said they struck it.
I'm not gonna put it on the record.
Okay.
You guys can call me afterwards.
I'll work
However,
on
it's
that, Mark. I can
referenced.
get that in
Yeah.
there.
Okay.
Yep.
And I will follow up again with Clark and I want to understand exactly what they do when they get somebody that's an alternate path. I think I know what the answer is.
Yeah.
But I'll get it in writing from them.
I'd be interested in that. I really would, to see exactly what,
Yeah.
How do they
Let 'em know.
coordinate that with what our law says?
Yeah,
You know?
well, like I said, I think I know the answer, but we probably won't be happy with it.
I think I know the answer too, and I also think our statute is not very strong, but that's,
Well, hey, again, if we can get some clarification and maybe they can start to flag some of these
yep.
for us, that's fine.
That's it. All right,
All right, all righty.
that one's done.
Moving on, item 5, new business. 5A, I believe we took care of this in discussion in the front end. 5B, applications. Caitlin,
Right, we have one, Mr. Chairman, and I sent the board the credentials.
mhm. Has everybody had the chance to review that? And are there any questions for Ms. Glasscock-Zabo?
Nope.
And that was you?
Yeah, I have no questions, correct.
Okay.
Yes. Ohio State University.
The Ohio State.
Exactly. Just like when I refer to you, you are the Mark Aragoni.
Yeah, yeah, exactly. Very, very similar, very similar.
comments from Phil.
No comment from me either.
Make a motion to approve.
So moved.
Second.
Phil, second. All those in favor?
Aye.
Aye. Oh, come on. I wanted a hard one. Like I wanted another Columbia one after, our mindset was so
Well,
into
I
it.
wasn't gonna soil her application, but if you did read through it, went to the Ohio State University, has been working in Pennsylvania and Massachusetts, has never stepped foot in Connecticut.
Understood.
And what we talked about last time, if Connecticut or if Massachusetts is having an issue, it's an awful long issue because we're getting a lot of them coming out of Mass and we get them coming out of New York too. So it's just interesting.
Yeah, I mean,
Isn't Stantec in Connecticut?
That office is in Massachusetts. The Stantec's
see.
all over the country. I mean, they're in Sarasota, Florida. They're in Long Island.
yeah.
Honestly, I think Mark hit the nail on the head a couple meetings ago when he pointed out that Connecticut just has a working board that acts on these applications.
That I'm telling you, the Massachusetts people, I just had somebody in our
Yeah.
Springfield office. It took her 9 months after passing the exam to
Yep.
get the board to act and give her a license.
So I think-
months.
I think that's it for sure. And Dom, I don't see anything nefarious about it, honestly. What is the issue?
Oh, it all goes back to Columbia. Columbia would have never gotten licensed in the state of New York.
Yeah, but that's a different issue.
Correct. But it's just interesting that people are seeking out Connecticut. It's not just here. I mean, we've had one from California that wasn't Lauren. Lauren works in Connecticut. We had one back in February or March or whatever from, they sought out from all the way over from California. I'm just watching.
But I think we know why they do that. I think we have identified why that's happening.
Yeah, I know. I think that this board is doing a lot of the right things at the moment, and hopefully we can clarify it. There's always going to be these gray ones that come in. There's no doubt about it. But I think we can definitely get our house in much better order and coordinate a little bit better, and maybe push back a little bit on Clark, make sure they're doing what they're supposed to be doing, and at least cover our bases.
Hey, it's $80 additional revenue for the state every year. We need every penny we can get.
Question, if the board has any power or right to ask someone like Catalin, why she's applying to Connecticut if she's in Massachusetts. I mean, Dom begs a good question, and so why not say what's the purpose, or is that not part of our purview?
I guess my question back would be, why do we care? I guess.
Right. That's what I'm getting to. And so, Ann, do you not accept the premise that it's because our board is functioning and processes applications much quicker than other states?
No, I accept that premise. I mean, when I've applied for licenses in other states, it's because I wanted to practice in those states.
Mm-hmm.
Well, that's different. That's reciprocal license. This is their first license.
Yep.
I see.
Yeah. There are issues.
It's just interesting to me. It'd be interesting to see if they they get their first license, they're established, and all of a sudden that license lapses in 2 years, or do they keep it forever? Or are they just using it as a gateway license to get a reciprocity into the state that they want to actually work in?
Yeah. I mean, and to your point, I mean, if you happen to bump into Caitlin somewhere and ask her, we'd all love to know the answer.
Yeah. So I'm just, it's curious. And if Connecticut is considered sort of a pushover for this.
Again, I don't think so. I think it's because we process applications and you can get a license much quicker. I think our requirements are the same, if not more strenuous in other states. And it's not hard to look at the requirements in other states, but it's been my experience that certainly Connecticut is not a quote pushover. We have the same rigorous requirements that other states do. I'm convinced anyway that it is because a person can get a license much quicker here in our state.
Yeah, and the beauty of it is, and I'll, you know, ASLE is going to watch it too as well. I would imagine. They know there's something going on, but we all know people that work for Stantec. You know, it's very easy to find out what the issue was, why they're, you know, maybe they're moving here. Maybe they're looking at it like
That's true.
if they're looking to expand and go down. I mean, landscape architects at Stantec run in New Haven. There is a group up in Boston, but maybe that person wants to relocate down here, gets the license, comes down here, settles into the New Haven area, even better. Home run, you know, another person to the state.
Maybe
Right.
there's been an opening or something. Okay, just curious. Okay,
Yeah.
I'm fine.
Okay, no, good
Happy to
discussion.
Move on.
Definitely.
5C, that's just administrative. Bob, anything interesting to note on those?
No, that's just to advise the board of the applications the department approved in the interim period.
Gotcha. 5D, no new applications for corporate practice. 5E, no joint practice applications. 6, any correspondence other than the Phil Doyle correspondence?
I have none, Mr. Chairman.
Okay. 7, we did have comments, but we took care of those. Anybody on the board want to bring anything up?
Yeah, one thing, I know we're running late. I just really want to try to fill the rest of our positions. I've been lax on it because of the pandemic, and Bob, I do, or Bob or Mark or Phil or anybody, and for that matter. One thing, even if the pandemic ended tomorrow, I'd like no discussion, you know, no movements on this, but we should start to think about, is this something DCP could move forward in, where we have a virtual meeting, even if the board is meeting in person? Some people can still call in. It might be a selling point to somebody who may want to sit on this board, the lay people, because I really feel like it'd be better off if we had the full panel, or at least close to the full slate of people involved in the actual process. I think it would suit us very well.
Well, yeah, I need to push back on that a little bit too. We have applicants.
Yeah.
At our last meeting, we asked Bob to check into what the status of those applicants are. So it's not, at this point, Dom, it's not an issue of people not wanting to be on the board. It's a function of them not getting approved and appointed,
Okay.
right? So Bob, you were going to check on where we stand with that. If they've lost track of the applications, if they're still sitting somewhere, we don't know the process.
I did reach out to the department. Honestly, I haven't heard back yet. I will do it again. You know, I know that they're, well, I'll send a contact to our liaison.
So, yeah, so I just think it's important to identify what the issues are. And I don't think the issue is we don't have people wanting to be on the board.
Well, I guess it's twofold then, Phil. I think it would be a benefit moving forward if they're going to start the conversation that, yeah, it's great to meet in person, but if one or two of the people are living up in the Northwest Hills or something, have a difficult time getting down there, if DCP is going to consider moving forward where we could have a video option for certain people, I think it's worked out pretty well.
I agree with that.
Yeah.
And furthermore, put it into the record that we do have at least 2 applications pending for board members for appointments, because I was worried about sunsetting. I worried about this dissolution of boards. So I want, you know, we have made, and thank you, Phil, because I think you've really championed it in the past of trying to get our board full and trying to do the operations that we're tasked to do. I think that's great.
Yeah, to sort of tag on to that one, I was on the DCP website and I had emailed Bob. I had just noticed that the makeup of our board was accurate on the DCP website. Phil was still listed as chairman, but when I was looking at it, I just asked Bob to update that one because it was still that way. But I said, geez, there's another opportunity that we should list that there are public member vacancies, and we should make it really easy for somebody to click on something via the website if they are an interested member or interested in being a member, whether they're landscape architects or a public member. Let's use the website to make it real easy for them to get there. So I had asked Bob in an email. So he was working on the simple change, Phil, from me to you. But also if there's a way right there to say, oh, you know, vacancies, public members, interest, click here. just to start getting a library of names and people and stuff like that. Any way that we can try and fill them is better. So Bob, you were working on that one to see what we can do to the website as well.
Yeah, I wasn't sure whether whether we can do that or not. That's another one that's brewing too. So I've got that feeler out.
So-
I got that question out there also.
Just to let the board know that that was something else we were trying to do.
Yeah, it'd be great to show up in the next couple of meetings and have a couple extra people on here. I think it would be so
Terrific.
welcomed, you know?
Mhm.
And Mark, just for the record, I did change the your title on the website.
Oh, great, thanks. That was the minor side of it, but
No,
Trying to
but
get
it was
things
something that
accurate.
needed to be- It's a little housekeeping. It was
Yeah.
a housekeeping issue. You're correct. That is fixed.
yep. Okay.
Now it says His Holiness Mark Aragon.
Right.
So one more question for me, and that is, how do I get on the next Zoom meeting?
Me too. I think I may have, if it came from a Zoom, I may have deleted it by accident, not knowing it was coming from you, Bob. I apologize. But
Me too.
You know what I've done with the architects board? One of our board members had the same issue. When I populate the meeting and it goes out, I can send you an email, Dom or Ann, saying, I just sent I just finished populating the Zoom webinar. Please confirm that you received something from Zoom. Please
Okay.
confirm you've also received you've been receiving the emails from me,
Yeah.
right, with the attachments and all that.
yes.
But I think the best thing I could do at this point is to send you an email the day I do it, right after I do it.
I would appreciate it, and I'll give you guys a
Be on
little
the lookout.
pandemic, but I completely cleaned out my Gmail account, so everything's organized in there, so I have
Yep.
nothing in my inbox. So when they come in, I organize it pretty well.
I've done that with the architects board with a couple people on the architects board, and it's worked out well. They've emailed me back confirming that they did get the link from Zoom,
Yeah.
and they were all set to go. So I can do that, Ann. I can do that, Don. But it's good for you.
Yeah, and I know
Okay.
what worked for me was when you get that Zoom link, it gives you the option to add to your calendar.
Yeah.
I just clicked on that and that's the link that actually works, the one that shows up in your calendar. Okay. I think we can end this meeting. Correct, Bob?
I have nothing else, Mark.
Okay.
We just need a motion.
Yeah, I make a motion to close the November 17th meeting.
Second.
All those in favor?
Aye.
Aye.
Thank you, everybody.
Thanks.
Yeah,
Good to see you.
this was a lively one. It seems like I'm happy that we have not had very many boring meetings in the past, which are good. Which are good.
Yeah.
And hopefully, and we can straighten out so we